Sa ongoing Senate impeachment trial ni Vice President Sara Duterte, may isang tanong na ngayon ang tumatagos sa lahat ng legal arguments, political maneuvering, at procedural debates surrounding Article 1 of the Articles of Impeachment. Ano ba talaga ang kinatatakutan ng prosecution na posibleng sabihin ni Colonel Lachica? Kasi kapag tinanggal mo lahat ng ingay, simple lang naman talaga yung issue. Hinihingi ng prosecution sa Senate Impeachment Court na suriin ang allegations involving the use of confidential funds ng Office of the Vice President. Gusto nilang i-evaluate ng mga senador sitting as impeachment judges kung paano ni-release, hinawakan, dinedocument at ultimately ginastos ang mga pondong iyon. At ayon mismo sa prosecution's own witness, former OVP Special Disbursing Officer Gina Acosta, P500 million ang nirelease in 4 tranches kay Colonel Lachica, ang dating head ng Vice Presidential Security and Protection Group. That immediately makes Lachica one of the most important figures in the entire factual chain. Hindi siya some distant official na incidental lang lumabas ang pangalan sa isang document. Siya raw mismo yung taong actual na tumanggap ng pera. Kung ang objective ng trial ay alamin kung ano talaga ang nangyari sa funds na iyon, then the obvious next question is unavoidable. Ano ang nangyari after matanggap ni Lachica yung pera? Saan napunta? Sino ang nagbigay sa kanya ng instructions? Anong operational activities ang involved? Anong documents ang meron? Anong security considerations ang nag-govern sa transactions? Sino ang may alam ng ano? Sino ang nag-authorize ng ano? At ano exactly ang role ng Vice President? Hindi peripheral questions ang mga ito. Diretso silang tumatama sa substance ng allegations. At sila Chica ang uniquely positioned para sagutin sila. That is precisely why dapat seryosong i-scrutinize yung reluctance ng prosecution na tawagin siya. House Trial Spokesperson Representative Robert Ace Barbers previously described calling Lachica as a risk for the prosecution. Think about what that actually means in the context of an impeachment trial. May central participant sa transactions na apparently considered risky dahil hindi alam ng prosecutors kung ano exactly ang sasabihin niya under oath. Pero iyon nga mismo ang dahilan kung bakit may testimony. Trials are not supposed to be exercises in assembling witnesses na nakamap out na in advance ang lahat ng sagot. Ang purpose ng trial is to establish facts through testimony, documentary evidence, questioning, cross-examination, contradiction, clarification, and ultimately judgment. Kung alam na natin exactly kung ano ang sasabihin ng bawat witness bago pa sila pumasok sa courtroom, then there would be very little reason to conduct a trial at all. The whole point of putting somebody under oath is to ask questions whose answers actually matter. At minsan, inconvenient yung answers. Sometimes, they strengthen the prosecution. Sometimes, they strengthen the defense. Sometimes, they complicate both sides. That is how fact-finding works. Representative Zia Alonto Adyong has likewise questioned why Lachica should be given the opportunity to explain his actions. Pero again, that raises an extraordinary question. Bakit nga ba dapat bigyan ng pagkakataon ang isang taong allegedly tumanggap ng hundreds of millions of pesos in question confidential funds para i-explain kung ano ang ginawa niya? Because that is exactly what a trial is supposed to determine. Kung naniniwala ang prosecutors na involved sila Chica sa irregular transactions, then his testimony could help establish those irregularities. Kung naniniwala silang kumilos siya based on instructions from someone higher in the chain of command, then his testimony could help identify those instructions. Kung may deficiencies sa documentation, pwede siyang tanungin tungkol doon. Kung may operational reasons behind certain expenditures, pwede siyang hinga ng explanation. Kung implausible ang answers niya, prosecutors can challenge him. Kung contradict ng recollection niya yung documents, prosecutors can confront him with those documents. Kung sumalungat ang testimony niya kina Acosta or Tonyo or anyone else, then the Senate Impeachment Court can evaluate those contradictions. That is not a weakness of the process. That is the process. Pero recently, kinumpirma ni Adyong na kinoconsider na ng prosecution na wag nang ituloy ang anumang request for a subpoena compelling Lachica's testimony before the Senate Impeachment Court. At mukhang heavily based sa prosecutorial strategy yung justification. Barbers has argued that because hindi nag-testify si Lachica during the 2024 House Committee on Good Government and Public Accountability Inquiry, wala silang baseline para ma-predict kung ano ang sasabihin niya under oath. That argument may make sense from the narrow perspective of litigation strategy. Of course, lawyers want predictable witnesses. Of course, prosecutors want witnesses whose testimony supports their theory of the case. Of course, every legal team thinks strategically about which witnesses to call. Pero impeachment is not an ordinary political press conference kung saan pinipili mo lang ang speakers dahil alam mong makakatulong ang statement nila sa communications narrative mo. The Senate is being asked to exercise one of the gravest constitutional responsibilities entrusted to it. The consequences involve removing an elected vice president from office and possibly disqualifying her from holding public office in the future. That gravity demands something more than tactical convenience. It demands completeness. It demands scrutiny. And above all, it demands confidence na walang relevant evidence na deliberately iniwan unexplored dahil lang baka guluhin nito yung theory ng isang side. The prosecution has suggested na witnesses such as Gina Acosta and OVP Assistant Secretary Lemuel Ortonio have already sufficiently established what it considers the Vice President's culpability. Kaya ang argument nila, baka unnecessary na ang testimony nila Lachica unless may additional evidentiary value itong maibibigay. Pero paano mo malalaman kung may additional evidentiary value si Lachica kung hindi mo pa nga naririnig kung ano ang alam niya? That is the logical problem. Hindi mo pwedeng sabihin hindi mo alam kung ano ang sasabihin ng witness. Tapos at the same time, confident kang unnecessary yung sasabihin niya. Those two propositions sit uneasily beside each other. Kung unknown ang testimony niya, then unknown din ang evidentiary significance nito. At kapag yung unknown witness na iyon happens to be the individual identified as the direct recipient of the question funds, mas nagiging important yung uncertainty, not less. Consider the chain being presented. Funds originated from the office of the Vice President. A special disbursing officer says she released the money. The money allegedly went to Lachica. Ngayon, may questions kung paano subsequently na-utilize yung funds. Kung gusto ng investigators na i-reconstruct ng buo yung chain, the person standing at the next crucial link is Lachica himself. Pwede mong tanungin yung taong nag-release ng funds. Pwede mong interrogate ang administrative officials. Pwede mong himayin ang acknowledgement receipts. Pwede mong scrutinize ang liquidation documents. Pwede mong pagdebatehan ang signatures, dates, certifications, at accounting procedures. Pero eventually, somebody has to ask the person who allegedly received the money, what did you do with it? Hindi mo kayang sagutin ng buo yung tanong na iyon through somebody else's testimony. At si Lachica mismo, pumasok na rin sa public discussion. On August 25, 2026, nag-release siya ng statement affirming his readiness to testify and tell the truth if lawfully summoned, subject to applicable laws and security restrictions. That makes the situation even more difficult to explain. Hindi ito witness na publicly refusing to cooperate. Hindi ito taong nagsasabing gagamitin niya every conceivable privilege para lang hindi humarap. This is a person publicly saying that if properly summoned, he is prepared to testify. So bakit ayaw siyang marinig ng prosecution? Maybe his testimony would support the prosecution. Maybe it would support the defense. Maybe parts of it would help one side and other parts would help the other. Nobody outside the process can responsibly know until he actually testifies. And that is exactly the point. The danger begins kapag ang legal proceeding mismo ay tinatrato ang uncertainty as something that must be avoided. Truth is inherently uncertain before evidence is examined. Witnesses are unpredictable because human memory is unpredictable. Documents can acquire different meanings kapag inilagay sa proper context. Testimonies can contradict one another. New facts can emerge. Assumptions can collapse. That is precisely why adversarial proceedings rely on examination and cross-examination instead of carefully curated public statements. Dapat interesado ang impeachment court sa kung ano talaga ang nangyari, even when the answer complicates the prosecution story. Dapat interesado rin to sa kung ano talaga ang nangyari, even when the answer complicates the defense's story. The constitutional question is larger than the tactical interests of either camp. At eventually, kailangang bumoto ng senators based on a record na tingin nilang sufficient para suportahan ang isa sa pinakamabigat na judgments na pwede nilang gawin. Imagine reaching that judgment habang alam mong may isang taong allegedly humawak ng 500 million at nasa center ng disputed transactions, available to testify, willing to testify, pero never questioned dahil considered unpredictable yung answers niya. Whatever your political position on Sara Duterte, that should raise concern. Supporters of the Vice President should want Lachica questioned. Critics of the Vice President should want Lachica questioned. Anyone genuinely interested in establishing the truth should want Lachica questioned. Because if the prosecution's theory is correct, Lachica's testimony may strengthen it. At kung ang testimony niya exposes weaknesses in that theory, senators need to know that before rendering judgment. The answer cannot depend on whether his testimony is politically convenient. May broader principle din na nakataya dito. Impeachment is inevitably political in the constitutional sense because elected officials prosecute the case and elected senators judge it. Pero hindi ibig sabihin na dahil political ang character nito, nawawala na yung obligation na seryosong i-examine ang evidence. If anything, mas lalong nagiging important ang procedural credibility. A divided public will scrutinize every decision, every excluded witness, every unanswered question, every document admitted, every document rejected, every apparent inconsistency. Kung gusto mo magkaroon ng legitimacy yung final judgment beyond one political faction, the proceedings themselves must appear capable of surviving scrutiny. And that requires confronting uncomfortable evidence instead of avoiding it. Hindi kailangang paniwalaan ng prosecution si Lachica. Hindi kailangang paniwalaan ng Senate si Lachica. At hindi rin pwedeng unilateral na mag-decide ang defense na testimony ni Lachica ang sasagot sa lahat. He simply needs to be heard, questioned, tested, challenged, and compared against the existing evidence. Let prosecutors ask him the difficult questions. Let the defense ask its questions. Let senators ask their own questions. Let documents be placed before him. Let inconsistencies be identified. Let him explain the mechanics of the transactions. Let him explain what he personally witnessed. Let him distinguish what he knows directly from what he merely heard from others. Then allow the impeachment court to evaluate his credibility. Mas persuasive iyon kaysa mag-iwan ng giant hole sa factual narrative tapos ipipilit na enough na raw yung existing witnesses. Because every time prosecutors publicly describe Lachica as unnecessary, unpredictable, or risky, they create another question na kailangan din nilang sagutin eventually. Kung irrelevant yung testimony niya, bakit siya pinagkatiwalaan ng ganitong kalaking role sa transactions na ini-investigate? Kung unreliable yung testimony niya, bakit hindi i-expose yung unreliability under oath? Kung contradict ng account niya yung documents, bakit hindi ipakita yung contradictions na iyon before the Senate? Kung i-confirm niya ang prosecution's allegations, bakit ayaw ng prosecutors na marinig siya ng impeachment court? At kung ang real concern ay baka magbigay siya ng explanations that weaken the prosecution's theory, then the issue becomes much more serious. A trial cannot become a mechanism for filtering reality until only the most useful pieces remain. The Senate is not being asked to judge the prosecution's ability to construct a persuasive narrative. It is being asked to judge the evidence against the Vice President. Those are not the same thing. A persuasive narrative selects facts. A credible judicial record tests them. And that brings us back to the original question. Ano ba talaga ang kinatatakutan ng prosecution na posibleng sabihin ni Colonel Lachica? Maybe nothing dramatic. Maybe his testimony would simply confirm what other witnesses have already said. Maybe he would provide operational details that fill gaps in the existing record. Maybe he would contradict certain witnesses. Maybe he would introduce entirely new information. Maybe his answers would raise additional questions. We do not know. The prosecution itself says it does not know. And precisely because nobody knows, hearing him becomes important. The answer to uncertainty cannot be silence. The answer to uncertainty is examination. Because if Lachica received the money, then ask him where it went. If he acted under instructions, ask him whose instructions. If he authorized expenditures, ask him why. If documentation is missing, ask him what happened to it. If there were legitimate security restrictions, establish those restrictions clearly. If laws prevent disclosure of certain operational details, let the Senate determine the proper procedure for handling sensitive information. There are mechanisms for dealing with confidentiality. There are mechanisms for protecting classified or security-sensitive information. What cannot become the default mechanism is simply refusing to ask. Ultimately, this is bigger than Colonel Lachica. It is about the credibility of the impeachment process itself. The public is being asked to trust that senators will eventually reach a judgment based on a fair and sufficiently complete record. Mas mahirap i-sustain yung trust na iyon kapag ang isang central participant sa transactions ay nananatiling wala sa witness stand dahil hindi ma-predict ng prosecutors yung testimony niya. Evidence should determine the theory. The theory should never determine which evidence the public is allowed to hear. If Colonel Raymond Dante Lachica knows something material about the P500 million he allegedly received, then let him say it under oath. Let prosecutors question him. Let the defense question him. Let the Senate question him. Then let the evidence speak for itself. Because the moment telling the truth becomes a risk to a prosecution, hindi na lang ang tanong kung ano ang alam ng witness. Ang mas malaking tanong na ngayon is this: bakit matatakot ang sino mang nagsasabing naghahanap siya ng katotohanan na malaman kung ano talaga ang totoo?
Thank you for watching. If you want to stay connected, you can follow me on my social media pages. If you want to support my work, you can do so through the following channels. Your support keeps my work independent. And if you found this video useful, consider subscribing to the channel. Like the video, leave a comment, and share it with someone who might need clarity on this topic. Every bit of engagement keeps this space alive, so I can keep talking to you directly.